May I please your Lordship?
Yes.
Lordship, I beg to mention item number 5. Lordship, due to some health reason, the conducting council is not present today. And we have taken the consent from the opposite council.
You have four
Respondent.
respondent.
Yes, your Lordship.
So have you informed the petitioner?
Yes, Lordship. Yes, Lordship.
Petitioner has consented.
Yes, Lordship.
You are Mr.
Tiga.
Submits that the conducting council has some personal difficulty due to what?
Health reason.
Okay. Has some health problem due to which he could not appear and pray for adjournment of the matter. For how many
2
days?
weeks, Lordship.
For 2 weeks.
Yes.
He has also obtained consent from the land council for the petitioner in view of the case and the case stand adjourned. List this matter after 2 weeks. Okay.
Lordship, item number 17.
Item
17.
17.
Yes, Lordship. And even the conducting council is a health issue, due to health issue.
Same.
Yes, Lordship.
Here you are for
Petitioner.
petitioner.
Yes, Lordship.
Mr.
Tiga.
So, Mr. The conducting council is indisposed and prays for adjournment of the matter for how many days?
Yes, Lordship. And Lordship, moreover, there is interim. So interim may be continued.
The prayer is allowed. List matter after 2 weeks. Stop. The interim order pass earlier, so continue to the next stage. Okay.
Deeply obliged.
My Lordship, may I mention item number 9? I am seeking adjournment. I am appearing for petitioner. The main counsel is not available on today due to his illness. Kindly adjourn the matter, if possible.
Okay, who is for the other side? State.
Item 9.
Item 9.
Okay. Matter was actually, Your Lordship, it was matter fixed today by this honorable court only, Your Lordship.
Okay. This is a fixed matter.
Yes, Your Lordship.
But then, you are mentioning on behalf of
Petitioner.
Hmm?
Petitioner, my Lord.
Petitioner.
Your Lordship, let the matter reach, Your Lordship. Since it was fixed matter, let the matter reach. The other side may also be there, Your Lordship. The private respondent is also there.
Let us see then.
Yes, Your Lordship.
I am for the petitioner, my Lord. Proxy counsel for Mr. Daya, Sandeep Daya.
Just a minute.
Lordship, may kindly see the yesterday order also, Your Lordship.
Okay, you are supposed to produce a case side.
Yes, Your Lordship.
Is it ready?
Yes, case there, Your Lordship. It was yesterday also we have produced it, and Your Lordship has direct us to retain it, Your Lordship. They're praying for quashing of the FIR, Your Lordship, on merit.
Yes, my Lord.
You are Mr.
Virender Singh. Virender Singh, my Lord.
Okay. So mentioning on behalf of Sandeep.
Yes, my Lord. Sandeep Daya.
So he is not there. Yeah.
Yes, Your Lordship. The respondent side is also there. If they are agreed, that I don't have any objection, Your Lordship.
My Lord, if I may kindly, I appear on behalf of respondent number 2, the complainant. Lords, they have been deliberately trying to delay this case. It has been,
No,
my
my
for
Lord.
long.
They are misleading.
Lords, since this was listed for final disposal, the sole reason is that
main
Okay.
counsel is
Mr. You are
ill.
Mr. Counsel for the petitioner. You are Mr.
Virender Singh.
Virendra Singh submits that the conducting counsel, Mr. Sandeep Dahiya, is indisposed. He is indisposed. And pray for adjournment of the matter. When do you want?
Yes, my lord.
Matter for 2 weeks. Or 1 week.
That is one, your lordship, 2 weeks and CD may be returned, your lordship. The investigation is
Okay.
progressing.
2 weeks. Stop.
My lords
There
may
is-
keep it for a
This is
shorter
matter
date,
after 3 weeks.
probably this week, my lords.
Mr. Ethe is ready with the CD. Let the CD be returned. Okay.
Yes, your lordship.
List this matter after 2 weeks.
Yeah. Deeply obliged, sir.
Oblige.
May I please, my lord?
Yes.
My lord, I beg to mention item number 19, my lord. I am for the appellant.
For
I am for the appellant, my lord.
appellant.
Yes.
What do you want
After 2 weeks, my lord.
after 2 weeks?
Yes, my lord.
What?
Yes, my lord.
Why?
My lord, the arguing counsel is out of station, my lord. Ditamo.
Appeal.
Yes.
LCR is also ready. Okay. Mr. You are Mr.
M. Doji, my lord.
Rambuji submits that the leading counsel, Mr. G. Tam, is out of station and hence pray for adjournment of the matter for
After 2 weeks, my lord.
2 weeks. The prayer is allowed. This matter after 2 weeks. Okay.
My lord, I have another mention, my lord. Item number 21, my lord. I am for the respondent here, my lord.
Okay.
I'm for the petitioner.
Hmm?
I'm for the petitioner.
Petitioner.
Yes.
What do you want
After 2 weeks, my lord.
after 2 weeks?
Yes.
You have any objection?
No.
Okay. Mr. Oh,
M. Doji.
the praise for listing this matter after 2 weeks, to which the land counsel for the petitioner has no objection. Prayer allowed. List this matter after 2 weeks.
My lord, there is an interim.
So, para. The interim order passed earlier shall continue till the next date. Okay.
Much obliged.
May I be please, Lordship? Your Lordship, I beg to mention item number 12 on behalf of Mr. T. Tafak. Your Lordship, this matter may be list after 3 weeks. Adjourned for an matter may be adjourned for today because in this case, Your Lordship, accused has to be referred before the investigation officer. But accused has been arrested and detained in custody in another case. So therefore,
Let us see the record. Let us see the record. Wait for some time. Okay. Let us see the record. Okay.
May I please, Lordship? Lordship, I beg to mention item number 6 on behalf of T. Topu. Lordship, the conducting counsel, due to personal difficulties, he could not appear.
Hmm?
Due to personal difficulties. T.
You are
Topu.
for
T. Topu.
respondent.
Yes, Lordship.
Who is for the petitioner? Have you informed the petitioner?
Yes.
Yes, Your Lordship, I'm for the petition on behalf of El Asa.
You have no objection.
No, Your Lordship.
Okay. Miss.
R.C. Lawangcha. R.C. Lawangcha.
Okay. Appearing of some mistakes. The conducting counsel, Mr. E. Topu, has some difficulty, personal difficulties today, and pray for adjournment. The prayer for adjournment is not objected by
After
the
3 weeks,
counsel for
Lordship.
the petitioner. Accordingly, the prayer is allowed. List this matter after 2 weeks. After 2 weeks.
3 weeks, Lordship.
3 weeks. Okay.
Oblige.
Your Honor, I'd like to mention item number 18.
Item
18,
18.
yes, Lordship.
What you want?
Lordship, I'm for the respondent on behalf of Pritam Tafo.
Okay,
The leading counsel is the leading counsel is have some difficulties. So may kindly fix this matter after 2 weeks.
okay. Who is for the petitioner here?
Lordship,
You have no objection.
no Lordship.
Okay.
There is an interim order, maybe continue.
Okay, you are Miss
P. Moyo.
Samistas, the leading counsel, Mr. Pritam Thakur, has some personal difficulties today and pray for adjournment. The prayer not objected. Hearing you. This is matter after
2 weeks.
2 weeks. Stop. Prayer. The interim order passed earlier, so continue to the next date. Okay.
Most obliged.
May I have a Lordship?
Yes.
Lordship, I beg to mention item number 13, Lordship.
30.
I'm for the respondent, Lordship.
Hmm?
I'm for the respondent. Item number 13, Lordship.
1-3.
Yes, Lordship.
This is in order column only. Wait for some time.
Lordship, here we have to file position, Lordship. And the leading counsel, Mr. T. Jamo, he is having some personal difficulties, Lordship. And in the meantime, Lordship, we have taken consent from the
Adjourn, we'll adjourn, but let us see the record. See,
Lordship.
be there for some time. We'll adjourn only. We'll allow your adjournment, adjournment
Okay, Lordship.
prayer. Wait for some time.
Okay, Lordship.
Oh.
May I beg your Lordship?
Yeah.
Your Lordship, this is a case, this is an anticipatory bail application, Your Lordship.
This one.
If Your Lordship may come to page number 13, Your Lordship, this is my annexure A. This is the complaint dated 23/9/2024.
Forgery.
Forgery, Your Lordship.
So that.
However, Your Lordship, the allegations are of 2022, Your Lordship. There is a delay of 2 years and more than 6 months, Your Lordship. This has come.
But then forgery was done in the year
2022,
2022.
Your Lordship. Yes, 2022.
You have also been appointed.
Yes, Your Lordship.
Okay.
There
On the
was no
basis of
obje-
the-
there
on
was
the basis of this
no, Your
forged
Lordship.
document.
No, Your Lordship, there is not a single complaint from the persons whose names are mentioned in this complaint, Your Lordship. This complaint has been filed by another person, Your Lordship. Till date, there is no,
Another person means
the complainant, Your Lordship, in this case. He has filed this case. Filed the present complaint, Your Lordship. Namely, Singde Nyago, Your Lordship. The allegations are that I have forged the signature of 5 persons, Your Lordship. But till date, none of the 5 persons has come before Your Lordship. Either
there
to
is
the
no allegation.
yes, Your Lordship.
Okay, but it seems the informant, whether his signature has been forged, whether it's
No,
any-
no, no, no,
any
no,
allegation?
no, no.
So he only alleged that the signature of
Other persons are forged,
and
Your
the other
Lordship.
person is not.
No, no, nothing. No. He's not. The other persons are even, in fact, the complainant also in this case.
Okay, yes.
See the perusal of case is required, Your Lordship. Let us see whether their statement, what their statement says, Your Lordship.
My Lord, before passing order, Your Lordship.
Okay, pardon, Mr.
T. Sring, Your Lordship. Your Lordship, I have already appeared before the police also, Your Lordship. My statement has already been taken.
Then.
There was a notice issued by the police. also.
Then
Now, Your Lordship,
you were not arrested.
no, Your Lordship.
Then what is the reason for your
Reason is
arrest?
that, Your Lordship, I am a traditional local priest, Your Lordship. I was here in Itanagar for conducting a local puja. Your Lordship. My family members have been questioned by the concerned IO.
No,
I'm
you
being
said
called
that
upon.
you have already appeared before the police,
My statement, yes, sir.
and your statement also has
Lordship.
already been recorded.
Lordship.
You were not
Have you-
arrested
No, Your Lordship.
despite your appearance.
No, Your
Then what is the reason, ground? for
Reason
your
is that, Your Lordship, I
apprehension?
am called upon by the police now, Your Lordship.
Again,
Again, Your Lordship, that it is being
saying what, saying what?
saying that I have to be arrested and produced before the court now, Your Lordship. Since this is a non-bailable offense.
Where have you stated that?
Your Lordship, paragraph number 4, Your Lordship.
Hmm?
Paragraph number 4, Your Lordship.
Paragraph 4.
Yes, Your Lordship. Operating parties, Your Lordship, page 5, Your Lordship.
Yes.
Third line, Your Lordship, from the top. Subsequently, the applicant visited the police station and has already given his statement and was allowed to leave. However, now the concerned investigating officer is repeatedly and constantly searching and inquiring about the applicant so as to arrest him, Your Lordship.
So according to you, there was no forgery.
This is what, Your Lordship. Till date, there is no complaint from the persons who are named in the FIR, Your Lordship, in the complaint, Your Lordship.
Mr. Solicitor, huh?
T. Sering, Your Lordship.
This is an application filed under section 482 of the Bharatiya Nagrik Suraksha Samhita 2023. Within bracket with 438 of the Code of Criminal Procedure. Corresponding to the section 438 of the Code of Criminal Procedure 1973. Praying for grant of pre-arrest bail, apprehending his arrest in connection with
Talia PS
Talia
case.
PS case number 07/2024 under section 468 IPC. Start. The case of the petition is that on the basis of the laws by 1 3 Sinde Nyagyo alleging there and that alleging for forgery of other signature of seal and signature of the other persons. Come, the police had registered in the above PS case. For offense under 468 IPC. It is submitted that the accused applicant is innocent. How he has appeared and appeared before the police. And appeared before the police, he has also given a statement under 161 CRPC. However, even after recording his statement, now the police is repeatedly and constantly searching and inquiring about him with a view to arrest him. And therefore, he has a reasonable apprehension that the police might arrest him and cause unnecessary harassment. Hence, this pre-arrest bail start. Issue notice. Since Mr. Patel appeared and accepted notice on behalf of the state, no formal notice need be issued. Call for the case study. The issue notice returnable by fixed date. Call for case study. Return. Scan copy of case.
14th, Your Lordship. Scan copy of case there.
Please this matter on 14th.
Yes.
Okay.
Your Lordship, maybe on 18, Your Lordship, which the PS is from is in Talia, Your Lordship.
18.
Upper Subansiri.
Upper Subansiri. 18th, Your Lordship.
Okay. In the meantime, comma. In the event of the accused, applicant being arrested in connection with the Thalia PS case number 07/2024 under section 468 IPC, he shall be released on interim anticipatory bail on execution of a bail bond of rupees 20,000 with one surety as life payment amount, with a further condition that he shall cooperate with the eye of the case and appear before him as and when called for, and also that he shall not tamper with the evidence of the case. Okay, list this matter on 18, nah? 18 or 19? Okay.
Obliged.
Yeah, please.
Yes.
Also, this is a joint petition for passing of the criminal proceeding on the basis of the mutual settlement.
Can it be done?
Lordship, the only one section is deterring the public servant. That is
Yes, that
the
is-
only. That only on that aspect I have an objection. Your
Yes,
Lordship.
that is
Against
why-
the
that
yes,
is why.
yes, Your Lordship.
While performing the duty.
Yes, Your Lordship.
So can it be?
They have to satisfy whether the section is attracted or not. If not attracted, no doubt it can be quashed. But if it is attracted, it's against the society, Your Lordship. It's a public against the public service.
Difficult.
Proceed, the fact is quite otherwise, proceed.
How?
Proceed, actually, the petitioner, lordship, the alleged accused of the case was wrongly implicated, yes, implicated, lordship. In fact, they were not at all involved in that.
It appears the case has already been charged sheeted, submitted in the charge sheet.
Yes, sir.
Is it?
Yes, lordship. It's
Then I think we didn't need to peruse the record. Whether it was, the police was on duty or not.
Yes, Your Lordship.
We'll have to see. Police will notice that.
Yes, Your Lordship.
Mr.
this again.
Okay. B Saikya, Land Council for the petition. Yeah. This is a joint petition. Filed under section 528 of the Bharatiya Nagarik Suraksha Sani 2023. Praying for quashing and setting aside the proceeding of Basar. Where is the GR case? Okay.
307. Less of 15.
GR, okay, proceeding of GR number 30715 arising out of Basar PS case number 08/2015 under section 332 353 of 34 IPC pending before the Land Court of Judicial Magistrate First Class Capital Complex.
Lordship, Chief Judicial Minister, Alas. Chief Judicial Minister.
So what is this then? Judicial Magistrate First Class Capital Complex.
Lordship,
So allo.
Lordship, Chief Judicial Minister, Alas. Might be.
You have written Land Court of Judicial Magistrate, you say.
Lordship,
See,
Copy.
page 1, post title. Down below.
Lordship, it's written as Chief Judicial.
Where? Page 1.
Lordship, it's, I apologize, it's a typography error.
Copy paste error.
Lordship, it will be correct.
Difficult. Correct this.
Lordship.
Chief Judicial Magistrate.
Allo.
Allo. Then you look for the. Okay. Issue notice returnable by
Lordship,
4 weeks.
Lordship, I have an interim prayer also. In the next day, Lordship, kindly the proceeding may be suspended.
No, It will be difficult because the case has already started.
Till next day only, Lordship.
What stage?
Lordship, in the stage of 313.
313?
Yes,
How can we stay then?
Yes, it is substantially proceeded, Your Lordship.
You have managed obtaining signature from the informant. They have already given their evidence. Everything is done. Okay.
Then 313, if they would have annexed all the deposition, then it would be quite
not
clear
a
for this
returnable
court to.
for
Yes,
the trial court record. Code for the. It will be a scanned copy of.
Yes, Your Lordship.
Scanned copy of the trial court record. Since Mr. Edgar has accepted notice. No formal notice required be issued to the respondent staff. List this matter after progress.
Obliged, Your Lordship.
May it please your lordship. May it please your lordship. Lordship, am I audible?
Yes, please.
Yes. Lordship, this is a matter of termination of work, my lord. I was awarded a work pursuant to a tender notice. If my lord comes to page 25, that was the tender bid. My lord, the name of the work, my lord will find at the top of this page, RFP for construction of 4 numbers of major permanent bridge with steel superstructure, through type with footpath NHDL clear carriageway with width 7.5 meter, having overall width inner width so and so so and so. My lord, this was the work. I was awarded the work pursuant to a tender, and the agreement was entered into, my lord, on 3/8/2022. From page 28 is the agreement.
Yes.
My lord, this the time period for completion of the work was 3 years, my lord. However, my lord, when we started to carry out the work, my lord, there were objections from the local people claiming the land to be theirs, and there was a hillock through which the trucks have to pass. That hillock was claimed by the local people to be theirs. Accordingly, my lord, I had informed the authorities. If my lord comes to page 33,
yes.
Page 33 is my letter intimating the hindrances faced. This on 1st of September. My lord will see that the date of the agreement was 3rd of August 2022. And thereafter, my lord, because of this hindrance, I'll read, my lord. With reference to the above cited subject, I'm unable to proceed to worksite with TNP and laborers, as some local people who claim to be landowners of the said worksite warned not to start the work unless land compensation issues are resolved. The following reasons are so and so, my lord. My lord, when the worksite is handed over to us, it has to be encumbrance-free. My lord, the local people, they claim the land to be theirs, so I could not proceed with the work. In fact, I have been intimating the authorities time and again, but there was no assistance made available to us. My lord, even they gave us show cause reply, my lord, on 18th of April 2024. Even in my reply, if my lord comes to page 59, page 55 is the show cause notice given on 18th of April 2024. Page 59 is my reply on 21st of April 2024, my lord. If my lord sees the first paragraph after serial number 12345, locals are not allowed to construction of bridge works due to non-payment of compensation.
Which page? Which page?
Page 59, my lord.
Page 59, my lord. Yes.
59.
Yes.
Locals are not allowed to construction of bridge works due to non-payment of compensation. Resolve this issue by firm by connecting various meetings with local and state civil authorities. After 12 months of this issue was resolved by paying compensation to locals by the firm. My lord, we had to pay some compensation. Only thereafter, we have been allowed to. My lord, we have transported the machineries to construct the work, to construct the bridges. Now, my lord, we are in a position to carry out the work. But now, my lord, what they have done, they have terminated the contract. And my lord knows these are bridges. And this is in the China border. My lord, if during the monsoon, due to heavy floods, landslides, we cannot carry out the work. But it is only in this season that we can carry out the work. Now, they have terminated the contract by the impugned order, my lord, 25th of October 2024, which Lordship will find from page 61. Page 61 is a termination order. They have given a very detailed one, but this is in violation of the contractual terms, my lord.
Yes.
Page 51, if my lord sees, this is under clause 23 of the contract agreement. My lord, there are a lot of whereases in this, my lord. Now, my lord may come to page 66.
Yes.
Clause 19, my lord, whereas the authority shall intimate the details of termination payment in accordance with clause 23.61, the valuation of unpaid work under clause 23.5, so and so, whereas the authority signatory of the contractor is directed to meet the undersigned with details pertaining to transfer of rights in accordance with clause 23.7 within 7 days of this termination notice. So and so, my lord, in conjunction with the contract termination, my lord, this is terminated. Now, this is under clause 23. Now, my lord, what does clause 23 say? My lord may come to page 21. No, sorry, my lord, page 80, my lord. Termination of contract, article 23. Page 80. I have annexed the relevant portions of the contract, my lord.
Yes.
Article 23, 23.1, termination for contractor's default. Now, my lord may turn to the next page, Roman 2 of clause 23.1.
Yes.
Without, towards the bottom of the page, Lordship finds it. Roman 2, my lord.
Yes.
Without prejudice to any other rights or remedies which the authority may have under this agreement, upon occurrence of a contractor default, the authority shall be entitled to terminate this agreement by issuing a termination notice to the contractor, provided that before issuing the termination notice, the authority shall, by a notice, inform the contractor of its intention to issue such termination notice and grant 15 days to the contractor to make representation, and may, after expiry of such 15 days, whether or not it is in receipt of such representation, issue the termination notice. Then Roman 3, my lord, the following shall apply in respect of cure of any of the defaults and or breaches of the agreement. A, the cure period shall commence from the date of notice by the authority to the contractor, asking the latter to cure the breach or default specified in such notice, so and so forth. So what I am on, my lord, is 23.1 Roman 2 lays down that for termination, the termination notice has to be given in the format of an intention to terminate. My lord, the termination notice has to be there. The termination notice has to give 15 days time. And only thereafter, they can terminate. And they have to give a cure period for curing the defect. My lord, this is not done in this instant case. Further, my lord, I admit there is a delay, but the delay is not on my part. The delay is in not handing over free possession of the site. When local people are there objecting to the work, claiming the land to be theirs, how can I proceed with the work? There would arise a law and order situation, my lord. I do not have any, even though this is border roads organization work, my lord, they do not give us any security. How can we carry out the work when there is a land compensation dispute going on with the people? My lord, in this, I'll not bother Lordship much with this. A similar matter was taken up yesterday by a coordinate bench in court number 1, my lord, yesterday. My learned friend is there, my lord. Similar work of the same organization, border roads, my lord, a different work order was there. That this honorable court was pleased to interfere, my lord, issue notice, and was pleased to grant an interim relief. I would pray for a similar order. And there is another order which I have annexed, my lord, in the petition of another coordinate bench of this honorable court, which order dated 27/3/2024 from page 90 and 91, my lord. this honorable court has been pleased to interfere, my lord. Yesterday's order, my lord, is on very similar work, my lord, that too of the bridge by border roads, my lord. That it was on the same grounds. This is just a different work order. And the same issues were there before court number 1 yesterday, my lord. Land acquisition, then, my lord, breach of clause 23.1, Roman 2, my lord.
Yes.
I'll pray for a similar order.
No notice was issued.
Notice was issued, my lord, towards the
Well, in
beginning.
fact, yes, the yesterday's matter, my lord, there is no specific about when by issuing notice to the matter, the respondent. However, my lord, since
My lord,
coming on after 3 weeks, my lord, we are ready to find a credible one. My lord, this is the same case, my lord. 2 packages of work has been awarded to this petitioner, and this is the same case, my lord, wherein there was a delay in executive work, my lord.
Yes, sir.
So accordingly terminated one. So at this stage, madam, may I present similar order may be passed since same package of work is different, but madam, the same contractor, same parties.
Same contract, same parties.
Yes, madam.
my lord, issuance of notice is reflected in paragraph 3 of the order, my lord, yesterday's order. The first page, my lord, just after the date, my lord.
Here, my lord, notice may be issued and my lord, the same interim period that may be considered. Only no courtship action. Since we have already terminated.
Or Mr. He denied land counsel for the petitioner. Also had Mr. Anka. You have filed KBit also.
Yes, madam. Yes. KBit 88.
Planet DFGI.
For all
representing the respondents. So KBit.
Yes.
For KBit. Stop. Yeah. By filing the present petition. Where is the impugn order?
My lord, from page 61, my lord.
Okay.
Annexure 17.
The petitioner has challenged the impugn termination order dated 10/2024, issued by the chief engineer, Project Arunank. Project Arunank.
Yes.
Okay. By which the contract work of construction of Four numbers.
Yes, my lord.
Four numbers of major permanent bridge with steel superstructure within bracket prototype with footpath bracket close 45 meters at kilometer 52.425 over Galo Nala, 45 meters span at kilometer 57.425 over Kogi Nala, 35 meters span at kilometer 60.080 and 35 meters span at kilometer 63.030 over Kojuk Nala on road Talia des Nacho under 77 RCC of 23 BRTF stroke project Arunank in Arunachal Pradesh. Awarded to the petitioner has been terminated, purportedly without issuing notice. Is required under notice is required under
My lord, 23.1 Roman 2, my lord.
required under clause 23.1 of the contract agreement. Stop. Issue notice to the returnable by 3 weeks.
Well, 3 weeks.
3 weeks. Stop. Since Mr. M. Carter, Lanet GI has entered appearance on behalf of appearance and accepted notice on behalf of all the respondents. So caveator, no formal notice is required to be issued to the said respondents. Stop. If furnished, however, we shall be furnished with the requisite extra copies of the petition during the course of the day. You are ready? Yes. Okay, during the course of the day. Stop. Para. List this matter after 3 weeks. Para. Till the returnable date. No question. Similar or that?
My lord.
Okay. No coercive action shall be taken pursuant to the order dated 25/10. 25/10/2024 issued by the Chief Engineer.
Yes.
Chief Engineer Project Arunank. Which district? Papumpare. Papumpare. Okay. District Papumpare, Arunachal Pradesh. Okay. So this is matter according after 3 weeks.
My lord, the caveat also may be discharged, my lord.
Since the caveat has been heard, the caveat stands discharged.
Well,
My deeply obliged.
My lord,
Yes.
my lord, the petitioner challenging impure order so and so ADC Palin. My lord, the petitioner is proprietor of MS distributor Nyapin, Prumkome, Arunachal Pradesh.
It was already destroyed
Already destroyed.
on the order of the executive magistrate.
Yes, madam.
Earlier, and thereafter only you started writing application for.
Lordship, during on matter is like that only delaying of the 4 hours of flying permit.
maybe 1 hour. Delay is delay only. You have no authority thereafter. Maybe 1 hour.
As the ground is like that, Your Honor. During that time, there is lots of nakas and
Yeah, that is why there are lot of naka during the election. You should have understood that that you are unauthorized person thereafter, after expiry of the permission. Unauthorized person. How can they allow?
Lordship,
The election time.
Lordship, flying permit, that's the flying permit is delayed. But flying permit is delaying. And I accept.
Permit after expiry, it's equivalent to no permit.
I accept that the flying permit is delaying, but the materials is not a illegal item. So
No, without permission, it is illegal item. Without permission. With permission, it's not illegal. You are correct. But without permission, it's illegal. And that is also during election time.
Lordship, my prayer is that as usual, we all know that the road condition of that's outside is not that much okay. Sometimes it's happen only 3 or 4 hour delay. It shouldn't be disposed.
Why it was to be in the last?
Lordship, it's been
expiry.
Lordship, it's been be like that. The expiry of the driver license and that's car should be disposed.
See, Annexure 10, page 46, there is an order. Have you seen this order? This was issued on 5th April. Destruction of seized liquor. Thereafter, only you started writing application. This was in April, and you started writing in the June.
Actually, Lordship, that's the concerned authority.
Knowingly, you started writing after the destruction of your.
No, Lordship.
Where is your first application? First application for.
Application is on 23/04/2024. 23 April 2024. Lordship, annexure number 5, page number 28.
This was written to district election officer. District election officer did not seize your material. Should have been with the proper authority.
Actually,
seize your
Lordship, this impute order is passed by election officer. May I page number 46? Annexure 10, 46.
Page 46.
Then the ADC come chairman of the committee is the main authority. And during the seizure of the
request for releasing of IMF, this also after order of the destruction. Destruction took place only on 5th April. You have started writing application on 23rd. After destruction only.
Actually,
knowing that it was already destroyed, you started writing.
Actually, Lordship, that's not my fault. My driver assured me that police personnel has verbally submitted that this seizure item should be released after the over of the election, assembly election. And everyone by morally.
See, just see, huh? Come to page 46 again. The order for destruction of the seized liquor. Okay, thereafter you see you have annexed the photographs also. It was destroyed in the public by using all those.
Lordship.
TV and all.
Lordship.
And thereafter also, thereafter only you have.
Lordship, come to page number 46.
Yes, what?
Your Majesty, here. It was done on 5th April, Madam.
Yes, 5th April.
Order, yes, Madam.
Lordship, actually it was done in 5th April, but I never No, it already disposed. And even
Because see-
after series of application, on page, Lordship, please come to page number 44. On 9th July 2024, they acknowledge me that your item has already disposed. On 9th July 2024. After series of application, I have written
But my lord, that series was done on 19,
and
19 March, my lord. It was after 1 month, my lord, he had filed the application, my lord.
that was the election time, no? And Your Honor, when I written the application, the Tax and Excise Department, Narcotics Department of Kurumkume had already.
There are 6 respondent, my lord. I'll be appearing for all the respondent, my lord.
Represent. You file affidavit, objection. Otherwise, just. Okay, we'll issue notice. You have Hardy case. You have to start it. Okay, hard, Mr.
TRR,
Planning Council for T.
RAR, Lordship.
RAR.
RAR, Lordship, even the amount is not that big, only 2 lakhs plus. Lordship, only petition has filed only because of the driver delaying of the 4 hours. The petitioner has victimized over the.
What is your prayer, by the way?
Compensation.
My prayer is for compensation.
How can you be compensated? Filing this writ petition. The petitioner prays for grant of compensation, direction for grant of compensation to those opposed to the petitioner due to destruction of seized liquor items. Due to seized liquor items. Of the petition. Issue notice. Returnable by 4 weeks. Since Ms. Wang appeared and accepted notice on behalf of all citizens, no formal notice need issued. So how the petitioner shall furnish requisite extra copies to the Land Council appearing on behalf of the respondent. We include the responsible staff. This is matter after 4 weeks. Okay.
Deeply obliged.
May I please, my lord?
Yes.
I am for the petitioner, my lord. My lord,
Lordship,
before making any kind of submission, my lord, I want to place some straight facts which acquire utmost seriousness to show that how the purity of the fountain of justice has been sullied.
Why it has been listed in addition?
My lord, it should have been listed for hearing.
This is already admitted.
It is already
It has
admitted
been-
on 4/9.
Yes.
But on 21 October, it was listed for admission again. And on 21st October, I apprised this honorable court that this has been listed, was to be listed for hearing. And this is a clear order on 21st. Can you
Yes.
see the order dated 21? It is very clear. But I am astonished, how come it is again listed for admission?
Well, it has been repeatedly listed.
Yes, that is,
Despite of the clear order.
and they have been directed repeatedly, first to file objection reply. They were not doing so. And when they are not getting any kind of relief from here, so this is happening, that it is repeatedly listed for admission in spite of clear order from this honorable court. And on the other hand, they are doing the illegality in the appellate court building. Kindly allow me, kindly bear with me, my lord, for a few moments. Let me place the chronological events. It can be disposed of in the admission stage also. My lord.
Have you filed objection?
No.
No, Lordship. Since
Why?
there is a confusing order from the learned court below,
Hmm.
Lordship, since this has not been clarified by the petitioner hearing also, Lordship, we kindly see this order, Lordship. In this very order, Lordship, the petitioner in the learned below has submitted that the endeavor will be made for amicable settlement, Lordship.
So, who is the miscellaneous petitioner? Is by the respondent hearing.
Yes. No, petitioner here. Lordship.
Petitioner, they have themselves filed. They themselves submitted that.
Yes, Lordship.
For making endeavor to settle the matter outside the court.
No, no.
Lordship.
The appellant there. B. Micro is the appellant, the respondent here. The council of.
The respondent here.
Yes. They were the appellant there.
Did they approach you for amicable settlement?
No, madam.
No, Lordship, that submission was made from the side of the petitioner.
The petitioner here.
Petitioner here in this revision petition. Lord.
Allow me to clarify, my lord. Kindly bear with me for a few moments.
Yes.
My lord, I am just placing the chronological events to reach to this order.
Just a minute.
Yes, ma'am.
What is this listing for list for hearing?
Lordship, that matter is going on in the learned court below, Lordship, PGM court rowing, Lordship. This is still going on, Lordship, since there is no stay in this instant case, Lordship.
I've seen some stay somewhere.
Lordship, that is IA, since there was a 2 appeal that was filed, there was a bit confusion that was going before the learned court below. The learned CGM has directed to file another writ appeal. So why the respondent herein has filed one writ appeal, which has been stayed. In fact, for one impugned judgment, Lordship, 2 appeal was filed. Already one appeal was pending. Another appeal was same analogous appeal was filed. The another appeal was stayed by this honorable court. They have approached this court in the form of IA, and that was stayed, Lordship.
The trial has been stayed.
Not entire trial, but that appeal that was filed subsequently. Appeal number 3.
Appeal.
Already one appeal
filed
was
before which court?
CGM, Lordship, who is the appellate court.
What
Here,
case- what-
hearing
The case was decided by?
Customary court.
Oh, customary court.
customary court, Lordship,
Appeal
and
is lying before the CGM.
CGM court, Lordship.
Civil judge.
Yes, ma'am.
So that is, there is one appeal, two appeal.
Two appeals.
Two appeal that was
One
filed.
against,
One impugned order, there is 2 appeal that was filed. One has been stayed, one is going on, Lordship.
against the same impugned order.
Same impugned order passed by the Gambora, Lordship.
Against the same impugned order, there is 2 appeal.
2 appeal
Filed
that
before
was
the civil judge.
Your Lordship.
Yes.
You, who have filed, who filed? Why?
Lordship,
Why to appeal?
there was a bit confusion that was going on, Lordship. So out of that confusion, that appeal
You
was,
have created confusion by filing to appeal.
that confusion, humbly I submit, Lordship, it was created by the learned judge, CGM, Lordship. That confusion was created.
Learned?
CGM, appellate court. Since he was the one who has directed us to file that appeal. Another appeal.
We have the order. Do you have the order?
Order as such.
During the pendency of the appeal, the learned CJM has directed to file another appeal.
Yes.
Do we have that order?
Order as such we don't have, but
Okay, but then the fact is that two appeal is pending against
appeal
one. Okay.
impugned.
So here, this is for what?
This is my lord. Let me put the facts, my lord.
Yes.
My lord, first customary court on 17/4/23 passed the judgment in our favor. It is a land dispute. So 17/4/2023, the limitation was 30 days. It was judgment. A rider was there that it can be from the date of receipt of the judgment. So they received the judgment on 10/5. The judgment was 17/4/2023. They received the copy of the judgment on 10/5. So the limitation expired on 10/6. They filed the appeal on 29/8, saying, giving some false ground on affidavit. They made false statement, deliberate. So we received notice on that delay confirmation petition because there was a delay preferring the appeal. So a delay confirmation petition was filed. So there they took 3 grounds, and all the 3 grounds were false. With evidence, we have placed on record while giving a reply, objection to the delay confirmation petition. But that was allowed. Delay was condoned. There was a perversity of finding and element of biasness. So we preferred a revision, which is pending here or here.
The present one.
Present revision. So according to us, the delay was more than 80 days.
Delay was more than
80 days. According to them, it was 74 days. But the court below held, it was only 11 days, surprisingly. So it is under challenge in the revision petition. Now, in that revision petition, kindly see my lord's order 16/7. They were seeking time again and again. My lord's own order is there, 16/7 in the revision petition. 16/7, 24.
Yes.
So heard so and so, Learned Counsel for petition and B Picha, Learned Counsel for appeal. Mr. Picha, Learned Counsel for praise aloud on the condition that this shall be the last opportunity to the respondent, last opportunity for objection. As prayed for by the Learned Counsel, we are appearing for the parties, list this matter again on 16/8 for admission hearing. In the meantime, the respondent shall file their objection, serving a copy to the petitioner at least 2 days prior to the next day of hearing. They did not do it. They never. On 16/8, the matter was again listed. So they were again given time, but they did not file. Then again, the matter was listed on 4/9. But in the meantime, what they did, they filed on 18. In the meantime,
on 4/9, it was admitted for hearing.
On 4/9, it was admitted for hearing because they were not filing.
And list it on so and so for hearing.
And in the meantime, there was some development before the appellate court below. What they did on 18/7, the matter was listed. The appeal was, my lord.
Just a minute. Why is it 4/9, 4/9/20?
4/9.
4/9, 2 order.
2 orders. One is I. We have to file an I because they were committing illegalities before the appellate court below. How they were committing? Let me place it. Kindly bear. On 18/7, on 16/7, this was listed. My lord has directed them to file reply 2 days prior to the next day fixed, 16/8. They did what they did. On 18/7, that matter was listed there. It was listed for appeal number 5. Because when they preferred an appeal, it was barred by limitation. They filed a limitation petition, condonation of for delay. In that, the appeal was registered as appeal number 5 and miss case number 96 for delay condonation petition. Now, in that appeal number 5, when it was listed, I apprised the court below that since I had on the delay condonation petition, it was in miss case, appeal was never registered until and unless delay is condoned.
Yes.
So it was wrongly numbered as number 5. It should have been a serial number. It was wrongly numbered. So it cannot be fixed for reply or hearing. So because appellant is not there, a respondent is not there, so notice need to be served. So accordingly on 18/7.
In condonation petition.
No, the delay was condoned.
Already condoned.
Yes, delay was condoned on 1/3/24.
In appeal 5.
In appeal number 5. So what the procedure is that after delay is condoned, the appeal ought to be registered.
Yes.
Then the appeal comes to the table. It ought to have been registered. And then notice, formal notice needs to be served. But instead of doing that, directly it was fixed for reply. So on 18/7, when it was listed before the appellate court below, I apprised the appellate court below that there was some irregularity. So it was wrongly registered as number 5. It should have been serial number. But anyway, it was a
No,
marriage.
you said that the delay was already condoned, then it will be registered only.
It was registered prior to that.
Okay.
When the miss case was registered,
So,
along with the miss case.
Mhm.
Instead, so it was the irregularity. So I appraised the court below to issue formal notice. The court was upheld. The court to take steps within 7 days. Issue notice, formal notice. They did not issue any, they did not take any step. So notice was never issued in appeal number 5 till date. Now, when this was pending here, probably they were thinking it was a simple matter of delay condonation, so it will get dismissed. So they were waiting. But on 16/8, when it was not dismissed, it was further admitted for hearing. They surprisingly, after 5 days, on 18/7, court directed them to issue take steps for issuing notice. On 22/7, after merely 5 days later, they preferred a fresh appeal. That is appeal number 3. And I is there, my lord. Kindly.
So in this appeal number 3, there was no delay. No condonation.
Against the same impugned judgment.
Against the same impugned judgment, but then there was a delay here also.
It was after
Was there any
48 days
condonation?
delay.
Was there any condonation?
No.
So this was admitted without condoning the delay.
Yes, but surprisingly, there is an order.
Now, which one is the main appeal?
Now, there is no main because
Both are pending before the
yes,
CJM.
in the same record, in 1/5. Now, what they did, they preferred a fresh appeal on 22/7. And there is an order, surprisingly, of the court below that since I have condoned the delay of 74 days 1 year back.
Whether the record was called for here in this case?
No.
I think the record is necessary here for hearing. Because what you are submitting is there is a lot of documents creating confusing as you say.
My lord, give me 5 minutes. First, their illegal acts has to come to the fore. They deliberately file a fresh appeal.
No, what is submitting is that as per the direction of the.
No, there is no direction. Kindly see the IMI.
So that's what the record need to be perused.
My lord, all the records, all the certified copies have been. I prayed for records.
No, records.
I prayed for records, but on 4/9, Honorable Justice P.J. Sekhar, he, as per his opinion, so records are not required.
No. The matter has already been stayed.
No, appeal number 3.
Only 3.
Only 3.
How
Because on 10/5, the interim prayer was rejected.
Now, what you are alleging,
Yes,
all these without record, how would we know? All these allegations, how would we know?
Well, then entire records may be called for.
Necessary only.
I prayed for, but on 4/9.
No, that will be necessary because During the appeal was registered without containing a delay.
No, no, first, there was,
First appeal, first.
delay was condoned. There cannot be two appeals, my lord.
No, no, the first one, five.
Five.
to submit.
It was numbered as 5,
Hmm.
but there was no memo of appeal. No notice was ever served.
See, we need to see the record.
Yes, no notice was ever served. So entire proceeding of the lower court has to be stated, an entire case record is to be closed. Otherwise, they are doing.
Now, according to you, which one is proceeding? The 5 is still
No,
proceeding.
my lords, kindly see this order which my learned friend has given before my lordship. It is 3. And kindly see order dated 4, passed by this honorable court.
On 4/9, it was stayed.
Stayed. They are hijacking. They are doing the things at their
But
whims
then
and caprices.
on 16/9, the same. No, this was stayed.
On
Appeal number
4/9.
3 was stayed. 3
was stayed.
But this is 5 again.
No, this order was 3.
Civil appeal number 5. This is 5 only.
Concern. We have taken the certified copy, my lord. The certified copy.
Now, if it is the same appeal,
Sir, Lordship,
the stay should have been 5 and
as
6.
submitted,
Yes.
Lordship, lot of confusion was created,
That is
Lordship.
right. That is
So votes will be required, Lordship.
My lord, this-
Everything will get clear,
Without
Lordship,
record,
once
how
we
do
get
we
the
know?
report.
No, I prayed for calling the records.
This is 3 again.
Yes.
This was also.
My lord, if my lord say go through the IA, my lord,
This is yesterday.
yes, yesterday's order. How
No,
come this
difficult, difficult.
this is clear content.
We need a record. And this original have to be called.
Yes, my lord.
No, not the scan copy.
No, all entire records and entire proceeding has to be stayed here,
It appears.
my lord. Their illegal thing has to
Against the
come to.
same impugn order, 2 civil appeal proceeding at the same time.
My lord, there is tampering with the order sheet. They have tampered with the order sheet. They have tampered with the notice. That's why I have filed the IA.
That will be more difficult.
To that effect, Lordship, there is a order from the CGM, Lordship. Everything is getting clear from the order of the
Fixed,
CGM.
my lord. It has to be.
My learned friend cannot allege like that,
No, no,
Lordship.
it is not allegation.
I have my
This is a serious allegation.
argument to
Yes,
make,
of course,
Lordship.
and I stand by that. We have proof, documented proof. They cannot run away like
Landed into difficulty. So forged means
tampering. IA is there with documents. And it is seen that the office at some level has been compromised. That is also there on record.
This is a serious allegation.
Of
Lordship.
course, I am standing by.
He cannot make
I'm
that kind of
ready.
allegation, Lordship, without any proof.
No, no, why they didn't file any reply? Till now, why they are running away?
That cannot be
Why
a
the
reason.
matter is
But this kind of allegations should not come from.
This is not allegation, my lord. Kindly, if my, I'm just taking responsibility for that. I'm standing by. Let them deny. What is preventing them from filing reply? Why they are not filing reply? Again and again and again and again.
And in the meantime, since you were directed to file reply also, you may also file in the meantime.
All right.
Because,
My lord, record
and
it.
at the same time, you will have to go through the record.
And the entire proceeding may be stayed. my lord.
Okay, Mr.
Ji sir.
G. Saikya, land counsel appearing on behalf of the land counsel for that. This is revision petition for the petition. Also had Mr. J. Z. land counsel for the respondent. Only one respondent, sole respondent.
Yes,
Sole
lord.
Start. Has presented this order passing miscellaneous application in appeal 5. It was you who presented, isn't it?
Yes.
Okay.
No, that day I was present, my lord. Family one.
Okay, Mr. Saikia. Now counsel for application of convicts that against the same impugn order dated,
Judgment,
impugn judgment dated
17/4/2023.
17/4/2023 passed by
Customary court.
the customary court.
Chidu.
Hmm?
Chidu.
Chidu. Chidu village.
Chidu village.
Chidu village. There is a two civil appeal. The civil appeal number 5/05/2023 and civil appeal number 03/2024 are pending before the Court of Civil Judge Senior Division, Roy. By an order dated by an order dated 4/9/2024, the further proceeding of civil appeal number 03/2024 has been stayed. However, despite of the stay order passed by this court from the state appeal, the Lanet Court of Civil Judge Senior Division, Roy, is proceeding
No judgment.
the trial of the state appeal, sorry, proceeding with the state appeal. Who appeared on 5th, no, on 5th in civil appeal number 3,
Both party.
both party appeared.
My junior, our junior also.
Okay.
Since it was listed.
And appeal number 5 and the civil appeal number 5/23 filed against the same impugn order, still proceeding.
Impugn judgment.
Same impugn judgment, sorry, impugn judgment is still proceeding before the court of the civil judge Senior Division.
In appeal number 5, there is no notice. No notice was ever or issued. In appeal number 5. In appeal number 3, three times notice was issued.
It is further submitted that the appeal number, the civil appeal case number 05/2023 is proceeding without any issue
Notice.
without issuing any notice upon the respondents.
Yes.
Yesterday,
So,
appeal number 5, yesterday's
Appeal number 3.
proceedings, court has directed to issue
No,
notice.
it's appeal number 3. Not 5. It was put on the carpet.
5,
Appeal
yes.
number 5. Yesterday is appeal number 3.
Appeal number 3 is already state law.
No, no.
appeal number 3 already.
Already state.
lower court.
It's not proceeding before the Lanet court below.
Despite
5 is
stay,
going on, lordship.
Despite stay. Despite
5,
stay.
5, there is no stay, lordship.
No, no.
5, there is no stay, your honor.
This is appeal number 3.
In view of the above submission, this court is of the opinion that the record of the entire record of the trial court would be necessary for proper adjudication of the case. So, accordingly, also the record of the civil appeal case number 05/2023 and the civil appeal case number 03/2024 from the Civil Judge Senior Division, Roy. List this matter after, it will take,
Maybe on
since we are calling for original, probably it will take time.
and
Since
further,
it's not a
entire further proceeding may be.
Okay. Okay.
Since records are cold, no,
They have to
no
be
space
speaking,
to.
because they will open B file.
Or if original records
No,
are
no.
cold,
What is the harm in speaking on it?
In the meantime, the further proceeding of civil appeal number 05/2023 pending before the Court of Civil Judge, Senior Division, shall remain stayed. List this matter after.
I would like to take your lordship attention to the last order. No further adjournment shall be granted to the respondent.
It's okay, it's okay. So now we have crossed that one, because without record, it will be difficult to dispose of this matter.
Because if they are granted time for objection, filing objection, they are not going to file. I'm sure about it. And they will seek time on that ground.
This is matter after 4 weeks. For hearing, will say. Okay. So in the meantime, the respondent shall also file their objection, if any. Okay.
And my lord, the problem with the bench section, my lord, because for two
No,
times.
this time, okay. Just a minute.
Date.
Second para, okay. In the second para, mention this one also. By an order dated 4/9/2024, this civil revision petition was admitted and directed for listing for hearing. However, despite of the said direction, the matter has been listed in the matter has been listed today in the admission column. So the registry shall verify.
On 21 also, there is order.
And the same. However, despite of such clear order, the civil revision petition was listed 21 where?
21/10. 21 October.
21/10.
Yes, ma'am.
It has not been mentioned here.
My lord. The revision petition, sir. This is list this matter on 6/11. Learned counsel for the respondent opposite party pays for and example. List this matter on 6/11. No further adjournment shall be granted to the respondent for filing.
Without mentioning hearing this.
The revision shall be filed for final disposal. For final disposal again.
With the other order stand, huh? Okay.
My lord,
The registry shall verify. Matter on 20. It's okay. The earlier, it was listed on admission column. Okay. The registry shall not. Registry shall verify before listing the matter. Verify the last order before listing the matter. Okay.
No, can I date it? Maybe because
After 4 weeks. Because
Can
we
I
do not know
23rd
now
of-
how, when it will,
23rd of December.
no, because we do not know whether it will arrive. The record will arrive on that day or not. It will be listed only after arrival of the record. Yes. Now, under the circumstances, we cannot fix the date.
23rd of December, because it's more than 4 weeks now, because I'm outstation, so it becomes difficult for me. Suddenly it comes to the list. If the date is fixed.
Okay, then, the last hearing is prayed for by the Nani Council for the petitioner. This is matter on
3rd of December.
3rd of December.
23rd is holiday, Your Lordship.
23rd holiday.
It's
23rd
High Court holiday.
23rd is High Court holiday.
24th.
24th is also holiday. I think probably that December,
Yes, December.
then I think
23rd is open.
23rd is open. Okay.
All right.
Obliged.
If I may,
Yes.
my lord.
Yeah.
My lord, this petition under section 482 is for quashing of the FIR registered under section 34A of the Arunachal Pradesh Excise Act. The FIR is at page number 11, starts from page number 11. The type copy is at page number 14, my lord. Basically, the allegation herein is that during the election time period,
Okay. So this is. There is also private respondent here.
yes, you know, they are
Appearing?
represented.
Yeah, respondent, okay. Just a minute. So this is to be actually. Your prayer is
For quashing of the FIR.
FIR.
Yes.
FIR itself.
FIR, and during the pendency lordship, a charge sheet was filed, so the subsequent charge sheet as well.
Who inquired?
Pardon,
Who
lordship.
inquired or investigated the case?
Police,
IO,
Itanagar
IO?
police station. yeah.
IO is a police.
Police lordship.
It should have been done by the excise official itself, Your Lordship.
As per the.
The excise is as per the, Your Lordship, Arunachal Pradesh Your Lordship, it's a very clear tax and excise rule, Your Lordship.
Okay.
Here, Your
It
Lordship,
has to be by the
by the excise officer itself. They are empowered under the code, under the rule. Actually, they are equipped with all the powers, Your Lordship, which are supposed to be done by the normally police. But here, special power, jurisdiction, everything has been empowered to the excise, Your Lordship, the inspector itself. It has to be done by them only.
Offense under the excise.
Yes, not by the investigation agency. Yes, Your Lordship.
Okay, but then complaint or the FIR was closed before?
Police, Your Lordship. This is the
Police.
error, Your Lordship. Yes.
Okay, that is why the police has investigated.
Yes, Your Lordship.
Okay,
But
with the assumption that they have a power.
yes, they have the power. Your Lordship, the procedure, everything is there in, Your Lordship may kindly see in the Arunachal Pradesh Code, Volume 7, Your Lordship. Everything will be clear from there, Your Lordship.
Page.
Your Lordship, it's Arunachal Excise Act, page number 62, Your Lordship will find in page number 62. If it is same.
Arunachal Pradesh Excise Act.
Yes, Your Lordship, 1993. Your Lordship, I will read out the appropriate provisions, Your Lordship. First, let's start with the provision. Rule number section 75A, cognizance of an offense. Now for
75A.
yes, Your Lordship. Yes, no 75 is no magistrate shall take cognizance of an offense. Page 99, Your Lordship.
Okay, no magistrate.
Yes, Your Lordship. Now the cognizance part. No cognizance shall take, no magistrate shall take cognizance of an offense. A.
Which one?
75, Your Lordship, section.
Okay, no magistrate.
Yes, shall take cognizance of an offense referred to A in section 34, section 37, section 43, or section 44, except on his own knowledge or suspicion, or on the complaint or report of an excise officer or an officer empowered in this behalf by the state government. Or B in section 45, section 49, clause D or clause E, or section 50, except the complaint or report of the collector authorized by the collector in this behalf. So these are the authority basing on which the magistrate can take cognizance. Here, it doesn't speak about, Your Lordship, on a report, police report. Now, Your Lordship, may come to this section 5, Your Lordship, the power.
In the instance case, what is the allegation offense?
Lordship, the alcohol was found in a wine shop, but the wine shop was operating from someplace else. Although the license was issued for someplace else, the wine shop was functioning at someplace else. So it comes under section 34, small a, Lordship, the offense.
It has been registered under section 34A of the Excise Act, Your Lordship, not under IPC. If it is registered under IPC, then it would have been different, Your Lordship. Only under section 34A of Arunachal Pradesh Excise Act 1968. So now, for the purpose of taking cognizance for an offense which is prescribed under Arunachal Pradesh Excise Act, these are the authority basing on whose complaint or even on suo motu the magistrate can take cognizance, but not on police report. Unlike section 190 of the CRPC. In CRPC, it clearly says report filed by the police or complaint. Here, report is not there. That part is absent, Your Lordship.
It has to be by the excise officer.
Yes, Your Lordship. And now, Your Lordship, the excise officer power is defined in section 65. Your Lordship, kindly come to page number 93, Your Lordship.
Section 90?
Section, no, page number 93, section 65, Your Lordship. Section 65.
Yes.
Yes, Your Lordship. Section 1. a collector may without the order of the magistrate investigate any offence punishable under this act, which a court having jurisdiction over the local area within the limit of collector's jurisdiction would have power to inquire into or try under the provision of chapter 15 of the Code of Criminal Procedure 1973 relating to the place of inquiry or trial. Subsection 2, Your Lordship. Any other excise officer especially empowered in this behalf by the state government in respect of all or any specific offence punishable under this act may, without the order of the magistrate, investigate any such offence a court having jurisdiction over the local area to which such officer is appointed would have power to inquire into or try under the aforesaid provision. Police has not been empowered, Your Lordship.
And they can power to inquire into and also try.
Yes, Your Lordship.
Power to inquire.
Yes, power to inquire, Your Lordship, and try under the aforesaid provision.
He would inquire as well as try.
Try, Your Lordship.
Both.
Both, Your Lordship. Here, again, Your Lordship will find.
It's four, I think.
Now, Your Lordship will see the section 6. Power and duties collector and certain offence investigation of investigating offences, Your Lordship.
66?
66, Your Lordship. Yes, 66 one. Any collector or excise officer empowered under section 65, subsection 2, may, after recording in writing his reason for suspecting the commission of an offence, which he is empowered to investigate, exercise A, any of the power conferred upon police officer making an investigation or upon an officer in charge of a police by section 160 to 171 of the CRPC. That means 161 statement can also be recorded by such officer. And B, as regard the offence punishable under section 34, section 37 and section 43 or section 44 of this act. Now here the section booked is section 34, Your Lordship. Here specifically mentioned for all these offences, any excise officer or the collector who is empowered, they can exercise the power of a police officer, Your Lordship. They are empowered, Your Lordship. Any of the power conferred upon police officer in respect of cognizable offence by clause A of subsection 1 of section 30 and by section 44 of the said code, and the said portion of the said code shall apply accordingly, subject to the restriction or modification prescribed. Now 2, subjected to any restriction prescribed by state government, a collector or the excise officer empowered under section 65 of the subsection 2 may, without reference to a magistrate and for reason to be recorded by him in writing, stop further proceeding against any person concerned or supposed to be concerned in any offence which he or excise officer subordinate to him as investigated. Now, their power, Your Lordship, what they can do, Your Lordship, without reference to the magistrate also, they can stop. 3. For this purpose of section 156 of the Code of Criminal Procedure 1973, the area to which an excise officer empowered under section 65, subsection 2 is appointed shall be deemed to be a police station, Your Lordship. And such officer shall be deemed to be officer in charge of the such station. Now they are absolutely given the power of police. As soon as investigated by a collector or by an excise officer empowered under section 65, subsection 2 has been completed, if it appears that there is sufficient evidence to justify the forwarding of the accused to magistrate, the investigation officer, unless he under subsection 2 of this section or under section 56 of this act, shall submit a report which shall, for the purpose of section 90 of the Code of Criminal Procedure, which Your Lordship we have already read, Your Lordship. This report will be filed by the excise officer or the collector, be deemed to be a police report to a magistrate having jurisdiction to inquire into or try the case and empowered to take cognizance of offence on police report. This is the power, Your Lordship. Here, Your Lordship, no any mention regarding empowering the police official to investigate the matter or to file report. It is the excise officer who is empowered under this act or the collector.
So this excise officer.
Yes, Your Lordship.
Can inquire
By himself.
And also file report.
Yes, Your Lordship.
Before the
Magistrate, concerned magistrate having jurisdiction to take cognizance under section 190, which is prescribed in section 74, which we 75, which we have already apprised, Your Lordship. If report is filed, then on basing on this report, the concerned magistrate having the empowered to take
file will be done by the magistrate.
Magistrate, yes, Your Lordship. If report is filed, Your Lordship. So now here in this case, the excise
report means the charge sheet.
yes, your lordship. But here the report means not by the police officer, but filed by the excise officer. But here in this case, the FIR itself is filed by the assistant inspector tax and excise, your lordship. FIR was filed by
In this case.
yes, your lordship. The assistant inspector of tax and excise himself he has filed. Actually, he himself has the power authority to investigate the matter.
Yes, sir. But
Yes.
he himself.
He himself has filed. Yes, sir.
Did not know his power.
Yes, your lordship. And he's
So what to
appearing.
do now?
It's a fact and all fairness, it's clear that with the rules and act that the inspector, excise inspector was supposed to do the investigation and file the report.
He
But
did not.
inadvertently or knowingly or unknowingly, he has filed that file. It is a wrong from his part.
So now the
Procedure has not been complied with, your lordship.
Hmm.
And it is a clear settled law in Bhajanlal case also, which has been reiterated in Nyarika also. Then when the procedure, statute provide a procedure to proceed further with the matter, investigation and all, then if such has not been complied with, then court can exercise its 482 power to quash the matter. Because it's a clearly abuse of process.
you have that.
Your lordship, yes. Bhajanlal.
Fair.
Bhajanlal, your lordship, para 1026, your lordship.
Yes, 102.
Yes, sir.
Para.
102, para 2 and 6, your lordship. May, your lordship, I don't have the copy, I will find out here, your lordship. Hmm. 102 para, your lordship. I will read out, your lordship. May I read, your lordship? 1026 is the operating one. I will directly read to guideline 6, your lordship, 1026.
Yes.
Where there is an express legal bar engrafted in any provision of the code or the concerned act under which a criminal proceeding is instituted to the institution and continuation of proceeding, and or where there is a specific provision in the code or the concerned act having efficacious redressal for the grievances of the aggrieved party. In such cases, your lordship, these are the guidelines basing on which the court can exercise its power. So to understand it better, your lordship, I will read from the very beginning of the 102, your lordship. Let's the parameter, but here 6 will apply, your lordship. I will read the 102.
Yes.
In the backdrop of the interpretation of the various relevant provision of the code under chapter 14 and of the principle of law enunciated by this court in the series of decision relating to the exercise of the extraordinary power under Article 226 or the inherent power under Section 482 of the Code, which we have extracted and reproduced above, we give the following category of case by way of illustration wherein such power could be exercised either to prevent abuse of process of any court or otherwise to secure the ends of justice, though it may not be possible to lay down any precise, clear, defined, and sufficiently channelized and inflexible guidelines or rigid formula and give an exhaustive list of myriad kind of cases wherein such power should be exercised. Now, under what circumstances this power can be exercised? 1. Where the allegation made in the FIR or the complaint, even if they are taken at their face value and accept in their entity, do not prima facie constitute any offense or make out any case against the accused. This will not come in this case. Where the allegation in the FIR and other material, if any accompanying the FIR, do not disclose a cognizable offense justifying an investigation by police under 156(1) of the Code, except under order of magistrate within the purview of Section 155(2) of the Code. This will not also come. 3. Where the uncontroverted allegation made in the FIR or the complaint and the evidence collected in support of the same do not disclose the commission of any offense and make out case against the accused. This will not also come. Where the allegation in the FIR do not constitute a cognizable but constitute only a non-cognizable offense, no investigation is permitted by the police officer without an order of the magistrate as contemplated under this will also not come. Where the allegation made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is a sufficient ground for proceeding against the accused. Now, Your Lordship, 6, this will come. Where there is a express legal bar engrafted in any of the provision of the code or the concerned act under which a criminal proceeding is instituted or to institute and continuation of the proceeding and or where there is a specific provision in the code or the concerned act providing efficacious redressal for the grievance of the aggrieved party. Here in the Excise Act, the effective, Your Lordship, procedure, everything has been provided, Your Lordship. So the question of invoking the CRPC, especially invoking the power of the police investigation officer, is not at all required. So here 6 will apply, Your Lordship. Where a criminal proceeding is manifest attend with malafide and where the proceeding is maliciously instituted with an ulterior motive or wreak vengeance on the accused and with a view to spite him due to private and personal grudge. 6 will apply, Your Lordship. Because there is a specific code to redress this grievance, Your Lordship. Excise Act, Your Lordship. And an exhaustive rule has, Your Lordship, provision has been provided, rules, Your Lordship. Power, everything, Your Lordship.
Respondent has filed any, nothing. Okay.
They are in fact admitting that yes, there is a procedure error committed by the
Yes. Okay. Mr.
Geeta, Your Lordship.
Land Council for the petition. I also have Mr. and an addition of people for the state of AP and Mr. T. Gatsa appearing on behalf of the respondent and respondent number 2. Who is this respondent number 2?
Inspector Excellence.
Okay, the one
Who lost the FIR?
Yes.
Okay. So this is in order, what column?
Admission, Your Lordship.
Admission.
Yes, Your
Okay.
Lordship.
I'll dispose of.
Yes, Your Lordship.
Okay. Yesterday's also.
Because Your Lordship, even if Your Lordship interfere, they always have a liberty to take initiate again.
Right.
Yes.
So, what we will do is I've kept some CAB also.
Okay, Your Lordship.
Because this is going to take.
Yes, sir.
because
Yes.
I have
Your
to-
Lordship, you have to explain all the provisions also. Yes. CAV, maybe yes.
Can it be kept? No, it's not in yet.
It's up to Your Lordship. Your Lordship, convenience. Because they are already, interim order is already there in this case.
Because I have to complete the other 2
Yes, Your Lordship.
this week. So if we can, what we'll do is we'll list it again for order.
Okay, Your Lordship.
On that day, I'll try.
Okay, Your Lordship.
Because keeping. Mhm. Mhm. Okay. List this matter again on Monday for further hearing.
Okay.
There will no, if there
Yes,
will
Your
no
Lordship.
for
Yes.
further hearing, but then I'll try to
Yes,
complete.
Your
If it is completed, then I'll do it.
Yes, Your Lordship.
Otherwise,
Interim order may be continued.
okay, in the meantime, the interim order for continue. Okay. So we'll continue. It too.
Much obliged.
Okay.
Mr. Antaji, Planning Council for the petitioner has mentioned to withdraw this bail application. Stop.
My lord, with liberty in case.
With liberty to file a fresh. Stop. This bail application is dismissed on being withdrawn with liberty is prayed for. Okay.
Oblige, my lord.
PP is not, this is item 10. After some time? Wait for some time then. Okay.
Hi, Lordship. Lordship, earlier I was I prayed for adjournment of this
Okay,
matter.
adjournment.
Yes, Your Lordship.
Okay. So,
Actually,
just a minute. Huh? Let us see. Order. What was the last order? Okay, there you are protected by an interim AB, that is why.
yes, Lordship. Lordship, on 26 September 2023, this CD was called.
So that is why, normally, when the,
Here in this case,
Hmm.
what exactly has happened, the accused is arrested in other case.
Yes.
So now the question for cooperating with investigation doesn't arise at all. So it's clear it will be therefore direct violation of the order passed by this honorable court. Because in other case, he is already arrested.
so what happened to the investigation, where the charge is filed? Because it is AB only,
It's a heavy lordship.
during
Here, what-
pendency.
yes, what-
Now,
What is happening?
Hmm.
They have moved anticipatory law. Here, this court has granted privilege of interim protection.
He was arrested in other case. In that order, interim order, he was directed to appear before the IO within 7 days, Your Lordship. So now here the question of appearing before the IO doesn't arise at all, and perhaps, Your Lordship, they have even unable to fail to execute, because execution of bail doesn't arise at all, because he cannot be shown arrested, since he has not been shown arrested in this present case, Your Lordship.
Lordship, on 26 September 2024, the CD was called, but the CD could not be produced because on that on that point of time, the IO was on long leave.
now.
That is why the accused person could not report before the IO. So his
No.
Your Lordship, I have just produced the case diary only to indicate that he is arrested in other matter, Your Lordship. And for that, Your Lordship, now initially the order was passed in, Your Lordship will see in 29/2024 by this honorable court, granting an interim protection. And in the meantime, Your Lordship, the accused was arrested in the other case, Your Lordship. So now question of appearing before the IO doesn't arise at all, Your Lordship, at this stage.
He appeared.
Yes, Your Lordship. As per the CD also, Your Lordship, he has never appeared.
He has been arrested in some other jurisdiction.
Yes, Your Lordship. Some other, Your Lordship, is there in the case diary, Your Lordship. He is arrested in other matter, and there are other cases pending against him.
Some other jurisdiction.
No, here, Your Lordship, here itself.
Lordship, another police station. This is case of PS Itanagar, and that case was the PS case of Simpur.
In Arunachal itself, Itanagar itself.
Itan.
Yes, Your Lordship. But in other case, Your Lordship. So now the question of cooperating with the investigation IO in this case doesn't arise at all. Your Lordship, for cooperation, the accused has to appear before the IO. Cooperation doesn't mean he has to admit everything, but cooperation means he has to appear before the IO.
What is the offense involved?
Your Lordship, 420 and 120B.
Okay. And in other case?
Same.
He's a habitual offender.
Okay, he is having.
Yes, Your Lordship.
Difficult.
What my humble prayer at this stage, Your Lordship, his bail.
He was
interim-
directed to appear before the IO within 7 days.
Yes, Your
Yes,
Lordship.
Lordship. At that point of time, IO was on leave. That is why he could not
So,
accept.
so this is already, you see, the condition 5. The petitioner shall appear before the IO within a period of 7 days from date of this order, failing which the interim protection so granted to the petitioner shall stand lapse by efflux of time.
Yes, Your Lordship.
Finish.
Yes.
Lordship, he was, that interim order was passed by this.
No, when he was arrested, you said, in another case,
Your Lordship is there in the case diary, Your Lordship will find in the right side, Your Lordship. I've just folded, Your Lordship. It's only mentioning that he is arrested in other case, Your Lordship. In this case diary itself, Your Lordship, yeah, that page only.
fourth time, it's after more than 7 days.
Yes, Your Lordship. So now at this stage, Your Lordship, the question of appearing before doesn't arise at all, Your Lordship, if he has not appeared.
Now his interim protection has also gone.
Yes, Your Lordship. This may be, Your Lordship, kindly be recorded in the order, Your Lordship, because for this case also his custody interrogation is required, Your Lordship. And since because he is arrested in the other case and there is interim protection, the concerned IO is unable to even show him arrest, Your Lordship. Formal arrest also cannot be
No,
done.
this is done it.
Yes, Your Lordship. But because the strength of this interim order,
Make prayer before the court.
he can be shown arrested because
No, in order to record his statement also.
Yes, Your Lordship.
And in order to show him.
Yes,
show
Your
him
Lordship.
arrested also.
Yes, Your Lordship. Because of this interim protection, no doubt, Your Lordship, in number 5 of the condition, it's written that so grant petitioner shall lapse by a flux of time. That is there, but Your Lordship, the express order, if until or unless there is express order from this honorable court, there is always your chances of Your Lordship this confusion, Your Lordship, jeopardize the Your Lordship interest of the court, this particular individual and the investigation agency as well. So it may be clearly reflect the order, Your Lordship. That
Now, where do we find that he was arrested on such and such date? It is only reflected in the case diary.
because, Your Lordship, this is
Inside the custody.
this case diary is pertain to the present bail application, but that case is pertain with the other one. For that case diary has to be called for, which is not before this court. For that case, they are not before this court, Your Lordship.
I only recorded that it has come to notice that the accused was arrested.
Yes, Your Lordship. It's another case, Your Lordship.
So, yeah,
And that record will be there with that case only, not in this case, Your Lordship. So now the question of appearing before the IO doesn't arise at all because he is already in the custody of the other police station. So it will be the violation of condition 5 also, Your Lordship. So what my humble prayer at this stage, Your Lordship, his interim protection may be vacated, Your Lordship. Because that clearly shows that, and he himself is admitting that he is arrested in other case also, the same section, Your Lordship.
no. Thereafter, the interim order continued.
Your Lordship.
Continued.
Yes,
continued on 26/9.
That is the problem, Your Lordship. Until or unless there is an express order by this honorable court, even if it is reflected in the condition, Your Lordship, it becomes difficulty for the prosecution side, Your Lordship.
But Lordship, on 26, the accused person surrendered himself before the IO, but because of that IO was on leave, his statement cannot be recorded. And thereafter, on 3rd October, he was arrested in connection with that simple case. Now he is still in the custody of police. That is why, Your Lordship, the matter may be adjourned for today. And
No, why the order was passed on 29? Why you had to wait for 26? Because the next date was fixed on 26.
Yes.
You have made an effort only on 26 when the case is already fixed before this court for hearing the matter.
actually,
You should have appeared before the eye of the case prior to
Your Lordship, as I have stated earlier, that IO was on long leave.
Now, where is your attendance before the appearing before the police station?
Actually, Your Lordship.
When the court direct the accused to appear before the eye of the case on within the period of such and such date, it is duty on your part in order to show, because the court wanted that whether you appeared or not, wanted to know on the next date. It is duty on your part to just go with the attendance.
Absolutely.
Please acknowledge my presence before the IO.
Your Lordship,
Having not done that, then You did not appear before.
Yes, absolutely correct.
Your Lordship, actually, we have filed in this PS case, his account was also freezed by the.
It is not connected to the account.
In
They
that,
are on the bail.
in that-
Naturally, because he is a habitual offender.
And your lordship, is a clear case. It's a privilege, anticipatory privilege bail, your lordship. Here he is submitting, he is arrested in another case with the same section, and now he is praying for continuation of interim protection.
Having committed this.
Yes, your lordship, same offense, your lordship.
Repeatedly.
How much privilege an accused is expecting who is committed same kind of offense in different places, in different occasion, your lordship.
No, on the next date also, 22/10, you made a prayer for listing this matter again on.
Yes, your lordship.
You have also not been truthful.
Since
It is their prayer every time, your lordship. Here also on the prayer of T. Tapak Lanet Council Body, we list this matter after 3 weeks. It is their prayer, your lordship. And they have not apprised this court regarding the arrest. Otherwise, the court would have recorded, your lordship, in the order. In the meantime, he is arrested. But now, today, after perusal of case diary, your lordship, even I come to know that, okay, he is already arrested in other case.
Hard, Mr. You are Mr. Jay Dalmo.
On behalf of T. Tapak.
Appearing on behalf of Mr. T. Tapak, Land Council for the petition. Start. Also hard, Mr. Land additional committee for the state of Vietnam. Start. Para. By an order dated para 20/09/2024, the accused petitioner was extended the provision of pre-arrest bail. And then while extending by an order that the sentence of this court, while extending the privilege of pre-arrest bail to the accused petitioner, has directed the petitioner to appear before the eye of the case within a period of 7 days from the said date. And failing which the interim protection so granted, so with the condition that in the event of this failure, the interim protection so granted to him shall stand lapse by efflux of time. And the next date of the case was fixed on 26/9/2024. The said interim anticipatory bail was subsequently extended on 26/9/24, 22/10/2024, and 22/4/2024. However, the since the interim protection granted to the accused petitioner on 2029. More than more than how many days? 50?
5 days.
Hmm?
More than 5 days. You were only 20. Initially, it was passed on 29, and subsequently the next day.
More than 45 days
Okay.
has elapsed.
Yes.
However, the case study reflect case study produced case study of case study produced before this court reflect that the accused has never appeared before the eye of the case and never reported or appeared before the eye of the case. Field staff. Today, the Islamic Council for the Petition submits that the accused has been arrested. The accused is unable to appear before the eye of the case as subsequently he has been arrested by which police, Chimpu police,
Yes.
arrested in connection with Chimpu PS case. He has been arrested in another case in connection with Chimpu PS case number 09/2024 under section 420 IPC. Start. From the record, from the record, it appears that the when the accused applicant had time and occasion to appear before the eye of the case, he did not appear as directed by as in terms of the interim protection, in terms of the condition number 5 of the interim pre-arrest bail granted to him. Now and now this is and now it has been informed that he has been arrested in another. He has been arrested in connection with another police, another PS case for commission of a similar nature of offense. That under the circumstances, this court is opinion that the accused petitioner does not deserve further extension of the pre-arrest of the interim pre-arrest bail granted to him on 20/09/2024. Accordingly, the same stand. It is vacated.
Vacated, yes, Lord.
Vacated.
You send vacated and disposed of.
Then what is the result of the bail?
Bail will be, your lordship, dismissed, your lordship.
No, Lord.
Today, your lordship, leading counsel, Mr. Tapak is also out of the station. This is a, matter maybe.
Even if he come also, the fact cannot be changed.
Yes.
Just a minute, the record has come. So what is the involvement? Have you seen?
Yes, your lordship, the other co-accused, they have stated his involvement, your lordship. 161 of the other co-accused has already been recorded.
Has implicated the
Yes, your
present
lordship.
accused.
Yes, your lordship.
Saying what?
That he is involved in, your lordship, this transaction. The total 9 lakh something is also there, your lordship, is there in the case diary, your lordship.
Para. On perusal of the record. There is a prima facie case against the accused for commission of the alleged offense. And the matter is still under the investigation.
Yes, he is still under investigation, your lordship.
How many accused are involved here in the instant case?
Your lordship, total, he is the main accused, your lordship. Your lordship may kindly find in the FIR itself, your lordship.
What? He is Dheeraj Pao,
Yes, your lordship. His name is Dheeraj Pao.
Karam Dugi, the others are also involved.
Yes, your lordship. Their statements are also recorded. Only his statement need to be recorded, but he is not appearing, and now he won't be able to appear since he has been arrested in the other case. They have taken money in the pretext of giving your tender work, your lordship.
The record also reveals that he is a habitual offender involved in multiple cases of financial fraud.
Your lordship, this is a.
There are 3 cases against him.
Yes, your lordship. Other cases are also.
Multiple cases of financial fraud involved in Giamali PS case number 05/2024 under section 406/420 IPC. Kimpu PS case number 09/2024 under section 420 IPC. CR case number 24/2024 under section 138/142 NIA Act. The present case is different.
This present case is, your lordship,
Itanagar
PS case number.
apart from the present
Yes,
case.
this is a case of
Apart
civil
from the
nature.
present case.
This is a case of civil nature. All the financial transaction has been done as per the agreement
Your lordship.
executed between the complainant and the.
In most of the occasion, offense of 420 is committed during commercial transaction only, your lordship.
And 1 lakh has been already received to the complainant.
Considering the nature of allegation and the material found against the accused on record, I am not inclined to, and also considering that the matter is still under investigation, I am not inclined to grant bail, extend the privilege of anticipatory bail to the accused at this stage. Accordingly, this bail application stands rejected. Dismissed.
Yes, sir. CD may be returned, your lordship. That may be.
Return the CD.
Yes, sir. Deeply obliged.
May I please?
Yes.
So this matters pertain to NDPS case, my lord. And
NDPS
in
case.
between quantity is involved, my lord. in between quantity is involved,
Okay.
21B,
21B.
and he is 67 days behind the bar. Last, my learned friend is submitting about the 187 regarding up to 10 years.
Okay. You were to satisfy that it is not
if he
90
have-
days, it is
my
60
lord-
days. Yeah.
My lord, if we have any further submission, he may submit, then I will submit.
Okay.
Further submission, I will clear the fact, Your Lordship, the incident has happened. The FIR was registered after implementation of the new code.
Hmm.
So new code will apply, and moreover, they have filed a bail application under section 483 of the CRPC or BNSS for release of the bail. Now they are praying for the default bail initially. If they are on default bail, my humble submission is as per 187 of the new BNSS, Your Lordship. It is not, it has been substantially changed, the wordings, and now the offense which is punishable extend to 10 years or will also come under the subclause 187, wherein, Your Lordship, the mandatory period would be 90 days, Your Lordship. And so far as merit is concerned, Your Lordship, he is also admitted, Your Lordship, that he is involved in selling contraband substances, Your Lordship. That much, Your Lordship. Nothing more to
Item
say.
8. Repeat in item 8. So it is, according to you, it is
90 days, yes, Your Lordship.
not 60.
Not 60 days.
Okay. So
Now.
yes.
Now, my lord,
Now you can start.
my lord.
Hmm.
Now kindly come to the Act Narcotic Drugs and Psychotherapy NDPS Act.
Yeah,
Section 30
NDPS.
Section 34A. Section 34A, plus 4.
Section.
Page 28, as per my.
Thirty-four.
34A 4, surplus 4.
NDPS Act 1985.
Yes,
34.
A.
There is no A. Is it
36A, 36A, madam. 36A,
36A.
A surplus 4.
Just a minute. 36A subclause 4.
Yes, yes, ma'am.
Yes, what is it?
In respect of merit, in respect of person accused of an offense under section 19 or section 24 or section 27A, or for offense involving commercial quantity, the reference in subsection 2 of section 167 of Code of Criminal Procedure 19so thereof to 90 days, where they occur shall be construed as reference to 180 days. Meaning thereby, my lord.
That is CRPC.
CRPC.
And then now BNS would be
DNS, that is why, my lord, where the special statutes speaks about under the trial will be concluded in 167 CRPC.
now the 167 BNS.
187.
187 BNS itself provides.
That is why, my lord, I will come this point on later. Now, my point is, if the statute is clear that this is falling under the CRPC, that it is clear. Even if, my lord, it was included after amendment, my lord, 36A. 36A was amended and included on CRPC, my lord. Now, my learned friends submit the judgment of two judges bench. Two judges bench, which cannot, my lord, hire the president of Rakesh Kumar Paul case. Because
What is Rakesh Kumar Paul case?
Rakesh Kumar Paul case is, my lord, up to 10 years or 10 years, which is reflected up to 10 years or 10 years. Can you see, my lord? I'm not intending to go elaborately, my lord. There is elaborate judgment. I just want to state that, my lord, straight last page.
Yes.
Point 3. In all cases where the minimum sentence is less than 10 years, but maximum sentence is not death or life imprisonment, then sentence under section 167 2A2 will apply, and the accused will be entitled to grant default bail after 60 days. That is clear, Miller.
Yes, it's clear.
Now, regarding default bail, my lord, there is another judgment.
No, how it is connected?
Because the statute specifically provides about CRPC.
Now the statute is BNS.
BNS, that is why, my lord. In BNS also, can you see the BNS first, my lord? In the
BNS. Now,
intro,
as per BNSS, is there any 60 days also?
Your Lordship, BNSS, there is a substantial change, Your Lordship. 90 day earlier, Your Lordship, the third was first is for death 90 days, life 90 days,
Yeah.
and imprisonment for a term 10 years or more. In there, earlier, it was
That was
not
60
less
days.
than 10 years.
It was, if it is less than 60, 10 years, then it would be 60 days.
Yes, Your Lordship.
But now it
It's
is
term
up to 10, 10
yes,
years
10 or
is-
more.
is
Yes,
10 or more.
extend for a term of
90
10
days.
or more. Yes.
It merged to the second one.
Yes, one. Yes, Your Lordship. So now, earlier, if the punishment, minimum punishment is 10 years, then only 90 days.
90 days earlier.
Extent will not fall on that category. But in the new BNSS, even the extent where punish can be turned to 10 years, then this will cover.
Now we have to see what is the punishment.
Exactly, Your Lordship.
that is why, punishment is up to 10 years.
Yes, yes. Then
21A.
Then as per BNS.
Then BNS, my lord. Therefore, I again submit, my lord. The NDPS Act specifically provides that this trial or any other factor regarding NDPS Act will be under the CRPC.
Okay. 167.
Then we will not, my lord, overcome the CRPC, the statutory provision of NDPS Act, because it is specifically mentioned in section 36 A plus 4. Now, if I go with his submission, my lord,
Yes, that is also clear that it doesn't come under 180 because it is yours is 21B.
yes, yes,
It doesn't come under 180 days. But then
Yes.
now come to BNSSS. BNSS.
now in specifically, if a statute specifically mentioned about specific act or procedure until it amendment, then we will follow the special statutes.
Yes. What the
special
special
section.
statute says.
this section 36A says that the proceeding under this act will be concluded as per CRPC.
Yes. And
That is why.
what is the CRPC says? What does CRPC says now?
CRPC says 167 supposed to.
No. Now you are governed by, now this
Yes.
case is governed by BNSS.
Yes,
Come
absolutely.
to BNSS now.
In case of BNSS, so
Now you have filed under BNSS. Now you
Yes.
cannot go back to
the
CRPC.
in this honorable court also,
Hmm.
even if in a case of 108 of Bharatiya Nyaya Sanhita, which is abatement of suicide, which imprisonment is, can you see my lord, Bharatiya Nyaya Sanhita 108?
Where is that?
BNS.
Kindly peruse my lord. 8 Bharatiya Nyaya Sanhita.
Have you given? BNS.
It's abatement of suicide. my lord.
BNS.
BNS.
Punishment here, penal provision. It's a
Abatement of
corresponding-
suicide, which punishment is up to 10 years.
Yes.
As per his submission, my lord, my
Yes.
learned friend's submission,
Yes, yes.
it is also included in the 90 days. Now, my lord, this court order, can you see this order of this honorable court? Here we will get default bail. Here we will get default bail after 60 days. Receipt order.
So where the relevant
Can
portion?
you see last portion? There is thousands of orders, my lord.
This issue has not been discussed here, Your Lordship.
Who was arrested in connection with so and so, so and so. Now, where it says,
Can you see my lord last paragraph?
now this probably was not properly
Yes, Your Lordship. Provision was not bring in the
explained,
notice
but
of
then
the court.
we can't change the statutory law.
Therefore, I again submit.
There's some, had it been challenged, it might not survive.
Yes,
also.
Your Lordship. This
But then
issue
how
was
do
not
we
discussed at all.
how do
That
we
issue
come
was
to-
not discussed, Your Lordship, which we are discussing right now.
Yes.
This issue was not discussed.
But my lord, the issue, if this issue is on the knowledge of this, my lord, my companion judge, my lord, they have also know the section 187. They also grant bail. So
Now
it's a my lord, my humble prayer is, it's a matter of liberty. Then if some other case like that, my lord, will instruct or will give many judgment or will
No, you-
discuss elaborately that
if you
it's
have a Supreme Court judgment,
liberty involved, my lord. So
if you have a Supreme Court judgment where even under this BNSS, so punishment up to 10 years has been treated as days, you can just present.
BNSS was
Because
My
as per our understanding, the
Yes.
law says that if the punishment is up to 10 years, then it has to be 90 days, as per the BNS. Earlier, of course, 167 CRPC, we understand, it's 60 days. But then now it has changed, and you have filed under this BNSS 2023 only. So which clearly says, can you just interpret, can you just read it once again, just for your understanding? Let us read once again,
my lord,
please.
187.
Yes,
187 or 34A, my lord.
187,
187, subsection 3, subclause 1.
184,
87.
187.
187, subsection 3, subclause 1.
subsection
3,
3,
subclause 1.
clause 1.
Yes, Your Lord.
Let us read. Let us forget this 34, because 34 talks about the section 24, 27A, etc.
Yes.
Okay, let us
Specific
forget it.
sections, specific sections
Specific section.
yes.
So
and commercial transaction.
yes, commercial.
This part doesn't cover here.
Yours is not in that. It doesn't come under.
It is my lord Supreme Court judgment, even if.
So if you're comparing, this talk about 180 days. This talk about 180 days, if I, under this specific section, offense. if the person is involved.
Section 36 itself said that all the proceedings will be concluded as per the provision of CRPC. It is a specific statute, my lord. NDPS is a specific statute. And
Yes.
If
Okay, let us come back to 34 then.
34.
Oh, no.
36A.
36A. What it says? It talks about section 19, 24, 27A.
and offense involving commercial quantity.
Offense involved with a commercial, and yours doesn't come under this.
Intermediate.
Yes, that is
Yours
why
is intermediate. It doesn't come under this.
that
Had your case come under this, then it would have been 180
80 days.
days only. You got me?
Yes, that is the point I will raise, my lord.
Yep.
Now can you see 36, my lord, initial part?
Yes.
Initial part. Notwithstanding anything contained in the Code of 1973, all offences under this act which are punishable with imprisonment for a term of more than 3 years shall be
Where
triable
are you
only
reading?
36A.
A, okay.
36A.
One subclause.
Yes.
My intention of submission this 36A is clear that if any offense done under NDPS Act, it will be concluded or trial will be concluded as per the criminal procedure act,
Yes.
not as per the BNS. Until and unless it's specifically provide that the trial of NDPS Act will be concluded under the BNSS.
What do you mean?
I mean, my lord, 36A specifically said that all the trial, all the eventual factor of NDPS Act, registered case under NDPS Act will be concluded as per CRPC.
Yes. Now BNSS.
BNSS cannot repeal the CRPC. BNSS.
Okay, let us see the
Repeal clause, saving and repeal clause here,
Let us
Lordship.
see.
For that, my lord,
It will be difficult now. Now it will be difficult.
No,
Yes, that is right.
Your Lordship, it's
Repeal provision.
528 per head. In many occasions, we 531, Your Lordship.
To satisfy you, we need to, of course.
And his case will not fall
500?
531.
31.
Yes, his case will not fall under
Do you
this.
have the BNSS?
Yes,
Copy of?
yes.
Okay, come to
531.
531.
Yes, Your Lordship. Now, Your Lordship, the one fact we have to clear, this case will not fall under the saving clause. Why? Because the FIR was registered.
He says that the CRPC not repealed.
Okay.
So to satisfy that,
Yes.
kindly read 531. Read it by yourself, please. Yes, repeal and saving. 531. You got?
Well,
Only one sentence. Read one sentence. 531. Repeal and savings. Just read one sentence. First sentence.
Not only first, all whole section is required. I will read.
Okay.
The Code of Criminal Procedure 1973 is hereby repealed.
Then
Notwithstanding such repealed, if immediately before the date of which is so and so submit come into force, there is any appeal, application, trial, inquiry, or investigation pending, then such appeal, application, trial, inquiry, or investigation shall be disposed of, continued, held, or made as the case may be, in accordance with the provision of the Code of Criminal Procedure, as in force immediately before such commencement, hereafter referred the code as if this Sanghita had not come into force.
Okay, let us come to your bail petition.
Now, your lordship may kindly see the FIR itself. It's very clear.
No, no,
FIR was
no,
lodged
bail
after
petition,
implementation only.
Bail petition, let us come to your bail petition now.
My lord.
Yes, please. This is filed under which section?
483 of BNSS. The corresponding section of repeal port.
An application under section 483 of the Bharatiya Nagrik Suraksha Sanhita 2023.
And who was arrested? FIR was registered after
And that was
implementation
after-
also.
After July only.
Yes. After July. So repeal clause will also not, saving clause will also not apply here.
It is BNSS only.
My lord, here I again come, my lord, because NDPS,
then,
NDPS Act is specifically mentioned about the CRPC.
No.
Actually, my learned senior counsel is trying to submit that even if it is repealed, but since the statute act specifically mentions CRPC, the CRPC has to be applied.
So it has to mention BNSS. You mean
According to him, yes. Your Lordship.
As per
According to
my
him.
knowledge,
Is
my
it
lord.
possible now?
No, not at all, your lordship. The special statute cannot, your lordship,
What is the stage of this?
keep this repeal procedure.
Today
alive.
listed for?
Hearing only, your lordship. Bail hearing. It's for final disposal.
Therefore,
it will be difficult now to make, to understand. So we need some space. Understand. Thereafter only you can come back.
well, then because it's a my lord,
You
matter
also,
related with the liberty of a person, my lord.
No, the
Yeah,
liberty,
that is
of
why
course,
I
your
said-
liberty is there, but that indefeasible right will be there after 90 days, your lordship. We are not saying this.
After expiry of 90 days, 60 days, as the case may be. The courts cannot also exercise their own independent decision.
My lord,
Yes, your
it's- everyone has, we have also.
We cannot
discussed-
exercise discretion if the provision is clear.
My lord. And
I am
I
trying
will,
to exercise my discretion here.
I will also submit one judgment, my lord, where the Supreme Court is specifically said that if a statute or a special act say about special section or special time or special day or special something, then other will be not interfering.
Now, after the issue of the BNSS and then all other acts, wherever the
Even in
be governed
POCSO,
by the CRPC,
even in POCSO,
then you mean to say that it has to be changed and that all has to be
And that-
amended, incorporating BNSS.
yes, yes.
That cannot be. That, of course,
Yes, your lordship.
after amendment, it will happen only,
Yes, your lordship.
but then as of now, it cannot be. So
That is-
what do we do is, this is NDPS.
This is NDPS case, your lordship. Otherwise, your lordship, if they are arguing on merit, we can argue on merit, your lordship, because
What is your submission on merit?
On merit is, my lord, it is my first crime and I am, as per my lord, as per my instruction, I was come with my car and two more follower will come with my car, my lord. They will bring this if something is brought. I am never, my lord, related with that things and this is my, as per FIR also, this is my first crime.
the lordship will see the
First
once-
crime.
My lord.
First-
As per the FIR also, this is my first crime. And I have, my lord,
What
lots
is
of.
the allegation?
The
You have-
statement, he has admitted that he, not only for the first time, in many occasions, he came for peddling the contraband substance. That is the statement of the accused itself.
Consumption may be first time, but.
Yes, peddling cannot be first time. That I have opened it, yes. That is the statement, your lordship. Your lordship, statement of the accused, I have just,
So earlier the magistrate, what is this? You have marked order of the magistrate.
Yes, Your Lordship may kindly see his statement, Your Lordship. I mark it the accused statement, Your Lordship, and the plague mark accused statement, Your Lordship.
Custodial statement is, my lord.
But for the purpose of bail, the custodial statement has to be taken into consideration.
His name is.
Yes.
Yes, non-dependent. Investigation is completed, my lord.
Investigation completed.
Completed, my statement is recorded, my lord. And I am only, as per FIR also, I am only the accused.
Okay. The sale craft, not to the circumstance. Where is the statement? What is this? The yellow mark is?
Which,
okay, bail objection.
perhaps it has been produced before earlier occasion. Before
What is this magistrate? Order?
Bail order is last part, my lord, in my petition.
You have appeared bail before the trial
Yes,
court?
yes.
It
No,
was
no,
rejected?
my lord. This is first attempt.
First attempt.
My lord.
Before
Why you did not
Before that, I will proceed, my lord, again, bail for bail, my lord. Can you see the last, my petition, the last?
What it says?
It says, my lord, still investigation is going on. Upon hearing the of the learned counsel on the procedural of perjury, I find sufficient incriminating material against the accused. But I also find above argument of the learned counsel the petitioner holding the no water. Therefore, considering seriousness of offense and this stage of investigation, and then
it was the bail rejected by the learned special court, Your Lordship.
Okay, special court rejected your bail.
Yes,
yes,
yes.
yes. Therefore, I am before
When it was?
it was rejected on, my lord,
18/9/24.
2024.
Okay, so
September.
Now I am 67 days on as on today.
okay, now
68
this is your prayer for bail now is on the expiry of the statutory period.
This is, my lord, before filing that 60 days, we filed the case, my lord, before 60 days. So it's on merit, man. Now
On merit.
Subsequently find that 60
Now
days
on
is
merit,
over.
what is the new ground you have taken? Because on merit, your bail was rejected by the learned. This is special.
My lord.
What is your submission now? For the new ground you have taken before this court, because on merit, your case was, your bail application was rejected.
My lord, there are 6 also. My 2 years old kid and wife is also in the operation. In the operation. But medical to go to 31, my lord. 30, 29. And only person, my lord, in my family. No, then my mother father also no. In the mountain.
How much, what is the quantity?
Can you see the FIR itself? In the FIR also, my lord,
77.9 grams.
there's 255 grams, my lord.
Intermediate quantity, more than small, less than commercial.
The injured is, and then the recovery at the time, and then his own statement before the police, all these sort of things.
Material is sufficient, Your Honor. So far as merit is concerned, they are not a fit case. Your Honor.
That will be, that is the point in the being trial manner. During trial manner, all over the manner. Institution is completed, nothing is left manner. All are recovered, documents are recovered. Manner are also released. There is nothing in the investigation now.
They are intact. Your Honor.
I no condition manner to bail them for the hard Mr. and government.
Non-counsel to the group. I'm also have Mr. This is an application. File number 64,
Nanandi, Nanandi, Purva.
Nayanji, data. Nayanji, who has been arrested in connection with case. So GR within bracket NDPS bracket close case number 36/24 arising out of BSA PS case number 14/2024 under section 21B of NDPS Act 1985. Stop. Para. The case of the petitioner is that based on the FIR lodged by one ASI Minjom Yomcha on 31/8/2024, the accused was arrested. A case was registered. The above case was registered. And the accused was arrested on 31/8/2024, and since then he has been lodged in the custody, inside the custody for about how many days you said? 67 days. Stop. Para. The land counsel for the petitioner initially submit that even after expiry of 67 days from the date of his arrest, since the IO has failed to file charge sheet into the case, from the petitioner is entitled to be released on before bail. However, as per the BNSS, as per section 187, 3(2) of BNSF, it is provided that 90 days where the investigation relates to 3I, it is provided that 90 days three, 90 days where the investigation relates to an offense punishable with death, imprisonment for life, or imprisonment for a term 10 years or more. So in view of the law provision of 187 3 subclause 3 1 I, the statutory period for completion of investigation entitling the petitioner for default bail is 90 days and not 60 days. Accordingly, the said prayer stands rejected. Stop. Back. Coming into the merit of the case, the FIR dated 31. In the FIR dated 31/8/2024 itself, the informant has stated that he has recovered a suspected heroin weighing 177.9 grams from the car vehicle driven by the accused Nayandeep Deka Barua at near Sunday Market area, Bordemsa. Stop. I have also perused the case that reproduced before this court. As per the recovery made from the accused and seized by the eye of the case has been corroborated by the witnesses, including the accused himself. The report further reveals that on 31/8/2024, by way to Bordumsa town area to sell drugs or narcotic substances to the drug consumer within the area. The accused was intercepted by the police team conducting narco checking on National Highway near Sunday Market. Sunday Market and 14 shop cases containing drug from back door of the car vehicle driven by the accused. Stop. The final edition PP for the summit stat. Madam, is the charge sheeted? Okay. The case is active investigation. And at this stage, if the accused is released on bail, there is every likelihood that he is the accused will hamper, it will hamper the release on bail. If at this stage the accused is released on bail, it will hamper the further investigation of the case. And there is also likelihood that he may jump bail. On perusal of the record and upon hearing the parties. Then, considering that, heard both the land council for the party. Upon hearing the parties and on perusal of the record, I find that there is sufficient incriminating material found against the accused for commission of the act. Accordingly, considering the seriousness of the allegation made against the accused for commission of the alleged offense and the material found on the case, and also considering that the matter is still under some stage of investigation, I am not inclined to grant bail to the accused at this stage. Accordingly, this bail application stands rejected. Return the case.
Deeply obliged, Your Lordship.
May I please, Lordship? Yeah, the Lordship, today, this morning, I have prayed for the time, Lordship.
Okay, so you want, when do you want?
Lordship may be listed after 3 weeks, Lordship.
This is
So,
transfer
Lordship,
petition
yes, Lordship.
after 3 weeks. You are
For respondent, Lordship.
okay, who is for the petition?
And Lordship,
You have no objection. Okay, Mr.
K. Tabang.
K.
Tabang.
Tabang. K. Tabang. Clearing counsel for the respondent. Praise for listing this matter after
3 weeks, Lordship.
3 weeks. To which the Clearing counsel for the petitioner has no objection. According to the list this matter after 3 weeks.
Give you.
Yes.
My Lordship,
Yes.
Lordship, I'm for the appellant. Steps have been taken through registered post with AD. Service is still awaited. So therefore, further time may be granted.
Okay. Miss
Margam Basar,
Clearing counsel for year for the
appellant.
appellant. Okay. The office note dated 5/11/24 to reflect the service upon the service in respect of the respondent number 1, 2, and 3 are still awaited in view of the above. List this matter after 2 weeks, 3 weeks,
Okay, 3,
3 weeks. Okay.
much appellant.
Yes. Completed. They have not appeared. What is this case? So they have received. Office notice is okay. So whether it's received from where is the report? Can we just see once the report, whether they have received or not? They have served, but then where? The service in respect of, so from your side, it is completed. Now we need, let us try to ensure which they have received. Taken step by way of registered post. Taken by the register. Land council for that. Little item. 15. From land council for the petition. The office note dated 31/7/2024 reflects that the service upon the respondent number 1, 2, and 3 has been completed. However, no one appears on behalf of them. How many respondents? What is your case? Let us see. Kebab is Kebang or Kebab? Kebang. Okay, where? Part by the second Bane. Bane is Kebang. Okay. They reviewed the decision passed by the who reviewed? Kebang. Okay. Deputy Commissioner passed order 19 in the year 1995. What about this? Kebang was passed expertly without the prevention of action. By filing this. Application under Article 227 of the Constitution of India. The petitioner has challenged the ex parte Kebang decision dated 6/5/2023 passed by the Tekang Bane Kebang, by which the said Kebang has reviewed the decision order dated 12/10/1998 passed by Deputy Commissioner Pasigar. Without any power and jurisdiction. Stop. The upon consideration, this civil revision petition, let this civil revision petition be admitted to hearing. Come there and stop. There list is matter to hearing after 3 weeks. Okay. Lordship, yeah. Lordship, yeah, need some more time to file our affidavit, counter affidavit. You are for respondent, yeah. You are for petition. Mr.
Neganyadong.
Mr. N. Chatung, on behalf of C. Modi. N. Chatung, appearing on behalf of Mr. C. Modi. Counsel for the respondent, prays for some more time. But prays for how much time you said? 3 weeks. Further 3 weeks time to file affidavit, counter affidavit. Okay, counter affidavit. So the prayer is allowed. This is matter after 3 weeks. Okay. So that's it. Yes.
No apparent petitioner side. Otherwise, your lordship, let them appear. Otherwise, your lordship, we have received a status report where it has stated that the case is culminated into FR.
Okay, then.
Then
The petitioner, no. Yeah.
let your lordship, let petitioner come, your lordship. Let petitioner come. Otherwise, your lordship, this case is culminated into final report.
Then it's, nothing remains then.
Yeah, nothing remains here, report, but your lordship, let them come, let the petitioner side come, your lordship.
Okay.
What is, there?
No one appears on behalf of the petitioner. In absence of the petitioner, the case stand adjourned. This is matter after.
A week, your
A
lordship.
week.
Yes. Deeply obliged.
Oh, this is in the, probably in the day. Day rejected there.